Some of you might know this feeling. You stand up, you look out over the audience, or in my usual day job, you look at the appellate bench, and you feel like you know all the answers. You've prepared your entire career for this moment. Well, for me, this isn't one of those moments. To begin with, the last time I really looked at seriously the issues of religious liberty was in 1979 when I was finishing up my term as editor-in-chief of the Harvard Civil Rights, Civil Liberties Law Review. And since then, I've sort of turned to other topics in my appellate practice, and a lot changes in the law in 35 years. And even back then, I was probably looking at it through a very different lens. The Law Journal was the Civil Rights-Civil Liberties Law Review. Little did I know that I probably should have been looking more closely at civil rights versus civil liberties. But we're lucky here today because we've got a little help from our friends. The question we'll be looking at is, when should a claim of religious belief exempt someone from complying with a law or policy? I've scripted out a few just very simple factual scenarios, and our panelists will help us walk through and tell us not only their views, but how we should approach the issues and how we should think about what we ourselves, each individually, think about the balance between civil rights and civil liberties, or in this case, religious belief and enforcement of laws or policies protecting civil rights. So here's the first one. I've scripted it out. Other than that, the panelists are totally unscripted, so it's going to be just as much a surprise to me as it is to you as to what they think of these fact patterns. Here's the first one. Suppose the Federal Transportation Security Administration, TSA, suppose they were to adopt a policy prohibiting its airport screeners from wearing any headwear while on duty. And a Muslim airport screener wears a headscarf, a hijab, for religious reasons. She challenges the policy as violating her constitutional freedom of religion. Jenny, how should we look at this?
Well, so first thing I would say is maybe time to have a little chat with plaintiff's counsel, because she doesn't want to be making a constitutional claim, actually. As folks may have in mind, the Supreme Court in 1990 in the Smith case determined that the standard for a free exercise claim against the government in this kind of setting is just going to be a rational basis review, and the government's going to be able to defend that rule fairly easily. However, Congress spoke up in 1993 in passing the Religious Freedom Restoration Act, and so she should be making a statutory claim under that statute, which would require the government to meet a strict scrutiny standard and having a compelling reason for saying no head covering, including the religiously required headscarf. And that might then lead to a testing of whatever the government might come up with. Could a headscarf possibly get in the way of pursuing somebody with an extra bottle of water in their luggage? Could it be difficult, I don't know, to use the equipment if there's a headscarf? It seems hard to imagine what the government would be able to say to justify that rule. But one of the things that is necessary under that test is that the government be using the least restrictive alternative. And I'll just flag for people that don't know, this particular fact pattern was cleverly taken from a case the Supreme Court is hearing that's actually a Title VII case against Abercrombie and Fitch. And the core of that case is the need for communication between a job applicant or an employee who needs a headscarf and an employer who wants to have a uniform look. And communication about how to do accommodation in Title VII and other contexts is very important. So we'll be looking to the Supreme Court to see how that should be done.
Professor, is that right? There's no viable constitutional claim there?
No, I respectfully disagree. The Smith case, Oregon versus Smith, says that if it's a law of general applicability, there probably will not be a constitutional claim. But here I would wonder if it's a discriminatory application. I would want to know what they were doing with yarmulkes for Jews and other types of dress. If they were just regulating Muslims' religious dress, it would be a classic violation of the Free Exercise Clause.
Okay, let's turn it around. Let's look at it from an employer's point of view. Next scenario. Suppose the owners of a family-owned winery believe that women should not serve alcohol. That's part of their religious belief. Because of their religious belief, they do not hire women in the tasting room of their winery. They hire women in the winery, just not in the tasting room. When sued by the state of NAPABA's Fair Employment Commission, they assert that they should be exempt from the state's employment discrimination laws based on their sincere religious belief. Jensen, you want to get us started?
Sure. So I'll fight the hypo a little bit as a good law student or lawyer, and just talk more generally about the importance of employment discrimination laws, because I think in these conversations it's really important to acknowledge that this is a balance, and it's protections for religious liberties are incredibly important and core to the history of this nation, as are anti-discrimination protections. And so the conversation I think we're really having is where is the right balance? And part of the conversation I think has been missing as of late is the incredible importance of employment discrimination protections to really help populations and communities who have been discriminated against for so long, and that has had a real negative impact. So if you think about LGBT people, for example, who make disproportionately less money than the general population, and that is primarily because of employment discrimination. The second point I just want to say about the importance of employment discriminations and anti-discrimination protections in general is that it also sends an important message. It's not just about regulating employers, but it sends a message to our entire society and country that these groups that we have decided to protect deserve the full humanity and dignity and to be treated with fairness and equality. And so I think that is incredibly important as well too. Once you start to weigh against those protections, you start to dilute the message that those laws are supposed to be sending to society. So now I'll answer your question really
So let
quickly.
me guess.
So-
the winery loses?
Yes, although, as a descriptive matter, it depends what state they're in. So because this is an application of an employment discrimination law, a state employment discrimination law, the RFRA that Jenny spoke about doesn't apply, and that's because the US Supreme Court has held in a later case, City of Plenary, that the RFRA could not apply to state laws. And so you gotta look at the state and whether or not they have adopted the Smith standard or not. I'm from Massachusetts. Massachusetts did not adopt the Smith standard. They still use the strict scrutiny test from prior to Smith, and they decided this in a case called Desolates. Now, Desolates in Massachusetts was a case where a landlord would not rent an apartment to an unmarried couple because they did not want to facilitate a couple living in sin. The court said that they had a free exercise right to deny that, and then they remanded to the trial court to determine whether or not there was less restrictive means and whatnot. And so if you're in a state like Massachusetts, then the court is going to have to go through that same analysis that the courts in the federal courts before Smith would have gone through. That said, as a normative matter, as what I think the outcome should be, is that there should not be a claim, a free exercise claim against anti-discrimination laws. One, because of the huge importance of anti-discrimination laws, which is what I started with, but also, how do you even enforce that? I think Diane Eck, who's a professor of religion at Harvard University, I heard her say once that the United States is the most religiously pluralistic country, not just in the world, but perhaps in history. And so once you start to create these exceptions for individuals, and we're not talking about churches or religious organizations, but for individuals, it becomes impractical.
Joe, what's the case to be made for the winery?
And so did you say Joe?
Yes.
And let me say first, thank you for having this. I think it's wonderful we get these perspectives. And I do want to add that from the perspective of an organization typically representing the religious interest, I do think we need to be careful. There's a tendency for people to talk past each other at times. Perspective is very important. And there's very much the dignity and rights of conscience of people who have deeply held, sincere religious convictions. And I don't think it's always so easy to assign the weight to one side. I think these are far more complex questions. I think that that's correct. You have to look at state law. Roughly just under 2/3 of the states have adopted either a state RFRA or the state Supreme Courts have adopted greater protection than that afforded by Smith. Smith, 1990, if it's a neutral, generally applicable law, the state wins. But with 2/3 of the state, and incidentally, quite a few states have not addressed the question of whether the state constitution has additional protections. But I think there are various issues that you look at. If there's a state RFRA and there's a sincerely held religious belief, the government now grapples with something like strict scrutiny, a compelling government interest, and the least restrictive means of achieving it. But as well, Smith doesn't answer the entire question because, as Jim said, it has to be a neutral law of general applicability. It cannot be targeted against religion. In the case like Lukumi versus Church of Babaluai, it may not single out church or religious treatment for disparate types of treatment. So there are other factors. It's actually a fairly complex question, but if there's state protection, I think the winery wins.
Okay, Joe, let's give you a little bit better set of facts for your position. Suppose a private high school in the state of NAPABA was founded by and funded by a church that adheres to the religious belief that marriage is a holy contract between a man and a woman. The high school recently posted a job opening for a receptionist, and in that posting informed applicants that it would not hire anyone who is married to someone of the same sex, as that would be inconsistent with the values of the school and the church. So an applicant sues under the state's employment discrimination laws. You going to take that case?
Yeah, absolutely. That's actually a very strong case for the school. The key is that it's founded by a church. Now, in theory, it's possible, I suppose, that a church could found a secular school, in which case it's a different analysis. But that would be contrary to my experience in the area. Generally, if the church starts a school, it will nearly always be either a religious school. If it operates under the 501c3 protection of the church, it's even stronger. If it's a separate 501c3, there are questions on whether the whether the school operates with a religious mission. There's a good case out of the Ninth Circuit called Spencer v. World Vision, nicely summarizes a 3-part test. You need to present yourself as a religious organization to the world. You need to operate consistent with those beliefs. You need to not have waived them by inaction. But the reason I think the school wins pretty easily is you have a 2011 case out of the Supreme Court, Hosanna Tabor versus EEOC. And Hosanna Tabor was, in fact, a Lutheran school started by a Lutheran church. And the Supreme Court upheld what's called the ministerial exception, and said that churches and religious organizations generally have very strong rights to hire and fire according to their beliefs. The EEOC urged the court to ground those in associative rights, and the court declined and grounded the decision in both free exercise and establishment clause concerns over issues of entanglement. It was a 9-0 decision, a concurring opinion by Justice Alito, joined by Justice Kagan, so you know this has broad support, said it is not only the minister, but anyone responsible for teaching the beliefs, communicating the beliefs of the organization. And so the one wrinkle in the question is that it's a receptionist. Someone, I suppose, might say a receptionist is not a theological position. But if, for example, the school required the receptionist to occasionally take part in devotions or to pray with people who call the school, or if there was some religious role to it, the protections for religious organizations, and they go back to cases like Amos and Serbian Orthodox and all of that, very, very strongly reaffirmed by the Supreme Court. And as well, you would look to see if you were exempt under the statute that the plaintiff is proceeding under.
So Jansen, I heard Joe say he thinks it's an easy case for the school. What do you think?
So I'm going to see if I can make it a little bit harder for Joe by actually talking about a real case that GLAAD is litigating right now that's very similar to this hypothetical. So in a case that we have right now against the Fontbonne Academy in Massachusetts, which is a religiously affiliated prep school in Massachusetts. They are operated by Order of Nuns, although they are affiliated with the Catholic Church. Our client, Matt, applied for a food services position, basically working in the cafeteria preparing food, and he got the job. And he came in to fill out his employment paperwork, and when he was filling out his emergency contact form, he listed his husband. And at that point, the headmaster said, "Oh, let me get back to you." Well, she did get back to him the next day, and unfortunately withdrew that employment offer from him. And so there are currently, as a descriptive matter again, there are currently strong protections for religious organizations and educational institutions for folks who have religious responsibilities, including Sunday school teachers and ministers and clergy. But it is a much harder, I think, call to argue that the person who is preparing the food for the children, and we're not talking about kosher meals or anything like that, has some type of religious responsibility in his job responsibilities. As my client Matt said in an interview, which I love, it's not like I'm flipping gay hamburgers or making gay muffins, right? And in fact, most of his job, in fact, all of his job would not entail any type of interaction with the students. And so again, you know, there are closed questions, and we have to find the right balance, but the state of affairs right now and many of the attempts to create these gaps in our anti-discrimination laws, which are so important, is far from the balance that we should be trying to strike.
And
Let's switch. Let's switch.
Kevin, could
Yeah.
I just want to expand a little bit on that point to take it one step actually from the context of education. I want to agree with Joe's point, or not agree, but acknowledge it. The Supreme Court, I think, in the Hosanna Tabor case, focused on clergy, that the ministerial exception is about clergy, and many religious organizations can define that broadly and have people providing religious functioning, pastoral counseling, and religious duties in a range of jobs. At the same time, many kinds of social services, medical services, as well as educational services are provided by religiously affiliated organizations where many of the job duties are not religious in nature, and many people of many faiths are employed by the organizations. And in fact, many times organizations are providing important services to the general public, frequently with public grants. And so I want to just spotlight a little for our thinking about this moving forward, because as Jansen said, I mean, this is an issue that's quite important to the LGBT movement, that we do some thinking about when functions are religious, when they should, when it's very important to be protecting them as religious, and at the same time, important to focus on the scope of religious exemptions in our non-discrimination laws. That's why Lambda Legal, GLAAD, and some of the other LGBT advocacy groups withdrew our support from the Employment Non-Discrimination Act, because we think it's very important that there be a proper focus on the need of employees to have protection against discrimination when an organization employs people of many faiths to do many types of work that are not religious in nature, that everybody then needs to be treated fairly at work.
Let's switch gears to public accommodations law, which Bill referred to in his opening remarks. So suppose a well-known local media artist specializes in creating wedding videos that convey the story of the couple's commitment to each other and their religion. The artist declines to create wedding videos for same-sex couples because, in her view, the messages inherent in such videos would conflict with her religious beliefs. So, the state of NAPABA's Civil Rights Commission has found that the artist has violated the state's public accommodations laws. Professor, Jim?
Well, in addition to a free exercise and free speech claims, the artists might have state law claims like the state RFRA or state constitutions we've mentioned. But I will leave that to the experts on that, and I will talk about the U.S. constitutional claims of free exercise and free speech. Now, free exercise, we've heard about the Smith case, which says if it's a law of general applicability, which this is, that there is no free exercise violation. So that's descriptively what the law is. Now, one could argue that Smith is wrong. Many people believe that's so. And so if Smith were, if the Constitution were properly interpreted by some lights, there would at least be some protection against burdensome regulations that unduly burden people's religious liberties. And I think that on that balance, it's a very difficult balance. For me, I come out on the side of the civil rights law. I think when someone is doing business in public, I think the right to be served equally outweighs even something as, why I do still have sympathy for this artist, which is based on a real case, is that it's almost like she's being forced to participate in a religious event that she finds to be contrary to her deeply held beliefs. So I think it's a hard case, and that's one of the problems of balancing these things. That's one of the reasons that maybe the Supreme Court got out of the business and told the judiciary to get out of this business, because that was Justice Scalia's point. How do we balance this stuff? Leave it to the legislatures and the state RFRAs. Now, the free speech claim here too. She's a video photographer. There's a video photography, and all photography has free speech. It's a free speech activity. And now this is a very, very complicated, so hard I would never give it as a final exam, right? But there's two different aspects of free speech. First is very similar to the free exercise one. What do you do with laws of general applicability that put incidental burdens? Aren't intended to go after the content of speech, because that would probably be bad, but incidentally burden speech. And then there's the very hard issue of compelled speech, going back to the cases you probably know about the mandatory flag salute that was struck down and the license plate that live free or die that someone said they didn't upheld his right to have that off his car. So how to analyze this, it would take a long time. I would think that the free speech claim is not even as strong as the religion claim, except that there is no Smith version of the free speech claim. So there might be some claim here, but I think the balance shifts even more sharply in favor of the civil rights laws. There is, to articulate exactly what the free speech claim is, I see the religion claim. The free speech claim is that she's going to be spending her artistic time editing and setting up shots. Okay, there's something there. There's something free speech. But that incidental burden, I think, is outweighed by the right of dignity that people have for people who are serving the public to be treated equally.
For those of you who are law students, look for it on your next con law exam.
May I just add something quickly?
Let's move on to the healthcare issues, because I think that's something.
I would really love to hear.
We'll come back to you, Joe. So let's look first to the compelling state interest. We've talked about public accommodations laws. We've talked about civil rights laws. And also, there have been asserted compelling state interests in reproductive rights. So, Dipti, this one's yours. The Federal Affordable Care Act requires employers to provide female employees with health insurance that includes free access to contraception. A medical partnership of deeply religious doctors who refuse to perform abortions asserts that requiring them to provide such insurance coverage to their employees would be inconsistent with their religious beliefs. The doctors have sued for declaratory relief, citing the Supreme Court's recent decision in Hobby Lobby. So I guess first you have to tell us what Hobby Lobby is about.
I do. So Hobby Lobby, what happened there? In a 5-4 decision, the Supreme Court held that some closely held companies can refuse to cover contraception in the health plans that they offer their employees. Now, these are health plans that would otherwise have to cover contraception without cost sharing because of the federal law, the Affordable Care Act. One thing I want to point out is Hobby Lobby only applies, as we've mentioned, to federal laws. Many states have state contraceptive equity laws that are untouched by Hobby Lobby. And so in those states, there might be protection for those employees that do not perhaps exist after Hobby Lobby in certain scenarios. So a claim under RFRA, we know, requires that the entity bringing it be considered a person. In Hobby Lobby, the Supreme Court said that in some instances, certain for-profit companies can be considered persons. For our purposes, the difference between a partnership and a closely held is probably not very important. But just because the doctors have religious beliefs does not mean that their partnership is a person for purposes of RFRA. And I think we'd want to know more facts than we have before us right now. And that's because in Hobby Lobby, central to the court's holding was that there was a unity of interest between the owners and the corporation, such that the religious beliefs of the owners was reflected in the business's corporate practices, right? And so here we'd want to know, do the partners all share a sincere religious belief? Do they run their business in accordance with that sincere religious belief? Do their business practices conform with this religious belief? Those are all questions we'd want to ask before we could determine whether this entity could ever bring a RFRA claim in this scenario. There's other questions we'd want to ask. So, the issue was raised is they object to contraception because it's abortion. Well, the medical community doesn't recognize contraception as abortion-inducing. To the medical community, entities like ACOG, a pregnancy happens when a fertilized egg implants in the uterus lining. But probably for our purposes, that's not very important, because for RFRA and under Hobby Lobby, we accept that their belief is that they object to these forms of contraception because of their religion. But we can still assess the sincerity of their beliefs. So have they held this belief consistently? Do they act in accordance with their belief? Are they, for example, funding companies that create these forms of contraception while at the same time say that they object to them?
Isn't it messy for courts to get into stuff like that?
Courts have always looked at the sincerity of a religious belief. So I think the case that comes to mind is in prisoner cases. Often we've had certain prisoners say, we have a religious belief that requires us to smoke marijuana. And sometimes the courts will say, well, you just came up with that right now. You've never actually practiced this religion before. There's all sorts of facts that allow courts to assess sincerity. They're not deciding whether your religious belief is accurate. They're not passing judgment on that, but they certainly can and they should be assessing the sincerity of a religious belief. And even in Alito's majority opinion, he says that in a footnote. He makes quite clear that a corporation's pretextual assertion of a religious belief could never qualify and bring a meritorious RFRA claim.
So how does a court weigh the significance of a compelling state interest? Is a civil rights policy by the government on par with a public accommodations right, on par with an assertion of an interest in health care or reproductive rights?
I think for me that's a very easy answer, yes. So I think you look at what purpose did the government had to pass this law. In the case of the federal law of the contraceptive coverage rule, we can look at gender equality. Women have disproportionately higher healthcare costs, in part because they're paying for services like contraception. There are standards of care that recommend that women, in fact, access contraception because preventing pregnancy is necessary if they have certain medical conditions, if they're taking certain medications for which a pregnancy would be contraindicated. And you would make that same analysis for public accommodations law.
Just out of curiosity, is there any data on how these issues might affect APA women?
Well, I don't know that we have that kind of data. We certainly have data about the ways in which API women have lower earnings, disproportionately lower earnings, or in the ways in which certain medical conditions, for example, diabetes, is more prevalent in the API community than it is in their white counterparts. And diabetes is a condition which most standards of medicine say you should plan your pregnancies, and planning your pregnancy requires that you be able to prevent a pregnancy when you're not ready to have one.
So, Joe, did you break out the bottles of champagne when Hobby Lobby came down?
We did, and let me add that, we had the companion case, Conestoga Wood, of the 20 forms of contraception, they objected to only 4, which they believed were abortifacients, and that was important for Justice Kennedy. But let me add as well that the state's interest in a compelling government interest test may not be a general interest like fighting discrimination. The Supreme Court, Justice Alito affirmed a case called Gonzalez versus Ospirito Beneficiente, however you say that the compelling government interest must be narrowly tailored to the individual affected in that context, and reaffirmed a generalized government interest is not sufficient for a compelling government interest.
So I wonder
Jenny?
if I could add a related point to this. I think the Hobby Lobby case has changed a number of the elements in the way the free exercise analysis is done, and it now gives us a great table full of questions about what's going to happen in future cases. I imagine that this is a point actually might be one of the few points that all of us agree on, that many questions ahead. And among the things that I think are going to be interesting is that Justice Alito's majority opinion says this analysis is not a shield for discrimination, and Justice Kennedy in his concurrence emphasized the idea that discrimination against coworkers or the discrimination problems are different, and there are compelling reasons to protect people against discrimination. And so among the things that I think will be interesting to see are what happens when because I should say the majority opinion does not give us a lot of guidance about how we should decide future cases. This is something that Justice Ginsburg amplified with some great vehemence and liveliness in her dissent. We don't know how to handle future cases. So what about the situation where we're talking about benefits, but it's not, as Joe says, for particular contraceptives where there's an objection and the government plan allows those benefits to be gotten another way. What if it's an objection to particular benefits for a particular person? Maybe same-sex spousal benefits. Unfortunately, we know from our work, I know Jansen encounters this too, employers who object to equal benefits for a same-sex spouse. Or what if it's an objection to a particular benefit if it's used, say, assisted reproduction as used by a lesbian, or hormone replacement therapy that's available for men after testicular cancer or menopausal women, but not for a transgender worker, where you put together the situation of coverage for something, but not for particular people. Because the majority opinion talks about discrimination based on race in hiring, and it leaves the questions on the table about whether that same analysis applies with respect to other kinds of discrimination and discrimination in benefits. And we know from the Supreme Court some decades ago, from the JC's case, the Supreme Court said there's a compelling interest in ending discrimination, that non-discrimination laws serve purposes of the highest order. And yet we haven't heard that echoed recently by the Supreme Court, and some of us are eager to hear that, to know that Justice Kennedy and Justice Alito's commitment to not having this be a shield for discrimination, that's going to apply in the range of cases, not just in the context of race discrimination.
So let's turn next to what the law should be. Here's a scenario. It's really just opening the door to the topic. Suppose a nonpartisan think tank is drafting a model state statute that would address the circumstances in which a claim of religious belief would exempt an individual or a business from complying with state laws governing employment or public accommodations. They have asked for a summary of your recommendations. Joe, this is right up your alley, but see if you can squish it down to 4 or 5 minutes, and then we'll open it for discussion.
It needs a very brief philosophical detour, because the starting point for me would be that religious protections are important and should be highly valued. And the reason for that is, I think philosophically, they are the cornerstone for all other protections that we enjoy. I would say that because the founders, I think, got that when Jefferson writes, not among the devout, we hold these truths to be self-evident, all men created equal, endowed by their creator with certain inalienable rights. People sometimes miss that this was a repudiation of the French Revolution, which worshipped the laity. The idea was that there's one of two possible sources for rights: the state, or that rights come here. I think somebody doesn't like my answer. They inherit naturally because we are created by God. And the founders believed that if they came from a creator where there was tyrannical government, it was even their obligation to overthrow tyrannical government. And I would just say that strong religious protections become the foundation of all rights because it says there's an authority higher than the state. If not, as we weaken religious protections, you may like what the state does now. I don't think you may not like it down the road, and there seems to be a totalitarian impulse that runs in humanity, and how do we protect ourselves from it? So I would start by saying it should be a high bar. The tolerance should be rightly understood as a two-way street, that there is a dignity, an inherent dignity to religious beliefs. And I think people have to understand, the photographer was our case, the people we represent in these cases, and they never say, I'm not going to serve gay persons. That doesn't happen. They don't want to celebrate the wedding if it violates their beliefs. These people are facing tens of thousands. We have a florist who will have to go personally bankrupt, customers for many years. She will face large six-figure fines and is essentially told, if you will not happily do same-sex weddings, you should be out of business. There's an inherent unfairness to this, as well as a lack of sensibility. Why would you compel someone to do an event that involves artistic talent if their heart is not in it? Would you hire a photographer? Gee, I'm sorry in the way on that one. Oh, that was a bad shot too. The point is more that we want to force you to do this. I don't think it's real tolerance. I think real tolerance is a two-way street, and you can't appropriate the word for its value, but then give a forced meaning like conformity. So I would say set the bar high.
You've got 1,000 people here who are going to go back to their states. What would you like them to tell their state legislators?
What I'd like to is there are genuine instances where religion loses. You can't say I have a religious objection to doing blood transfusions if you work in the emergency room. If you have other exemptions, you cannot deny religious exemptions. Hobby Lobby, the government lost in part because there were millions of people exempt under grandfathered policies, religious organizations. You can't have a wide variety of other exemptions and say religion is treated less favorably. I would say also consider factors. Corporations should be considered businesses, particularly after Hobby Lobby. And then look at other factors. For example, the photographer case or the florist case in Washington, there were dozens of other people, florists, photographers, happy to do those services and to charge less. So my view would be, why compel someone to violate their beliefs if the services are generally available? I would look at other factors. If the services are not available, then that would be a factor in favor of requiring the person to do the service. If it's a genuine public accommodation, I agree. There should be no discrimination. If it's a hotel, a restaurant, absolutely. But I do think that when you look at those factors, you want to capture the sensibility that this is really a complex two-part consideration. We may talk about discrimination, but I don't think I'd like to tell a Catholic hospital you are compelled to do abortions. If religious motivations encourage them to serve that way initially, I think government should take it very carefully before we compel people to violate their sincerely held religious beliefs. I think there is an appropriate high bar. We should remember rights of conscience are intimately related to our defining religious beliefs. So all of those.
Let me break in there. Jenny, a bill gets proposed in a state. What are you and your organization going to be telling the state legislature? What's wrong with the bill?
Well, and so, this hypo does draw directly from the scenario we had this past spring here in Arizona with SB 1062. And I do want to say how much I and colleagues in the LGBT movement appreciated the stance that NAPABA took in conveying to the governor that if she signed that bill, that this conference would not be held here. Many people communicated that message to her, but I was particularly proud and gratified that this organization did. I want to say personally thank you about that. And what I would say to the legislators, what we did say and what we are saying in other places where these arguments are being made and bills of this sort are being proposed, is that yes, indeed, religious faith is very important. Respecting diversity of belief is incredibly important, especially, as was said, in a country that has such diverse beliefs, but I think anywhere it's true. But it also has been true from the founding of this country that the protection is for belief, absolutely protect belief, but conduct always has been regulated. And when people choose to engage in a business, select a field of commerce, then people have to be willing to follow the laws that apply in that field that protect other people, including protecting all of us from the dignitary harm of being turned away based on just who we are. The civil rights movement, the sit-ins in the lunch counter, it was not because there were no other places to get a sandwich. It's because each of us is entitled to be served as other people are served and not being turned away because somebody says, I have a religious reason for saying I cannot serve you. If you've chosen to go into the sandwich business or the florist business or the wedding cake business, then serve all the customers. And if you have a religious belief that you can't take photographs for everybody at weddings, then take photographs at birthday parties instead. But each individual knows what her own religious commitments are, and the duty should be on each of us in the first instance to find that harmony between our religious commitments and not behaving during our business interactions in ways that undermine the dignity of other people. And so I think the key thing is to honor the idea that in the commercial sphere, if it's about money, of course there can be religious commitments that we all have, but we're not entitled to hurt other people. I do also, I will say, disagree with the idea that corporations should be treated as individuals who are exercising religion. I think the Supreme Court got that wrong. Many people think the Supreme Court got that wrong, and we certainly should not be enshrining that principle in state law. And I just want to say, I think if we all make a point of respecting each other, it is consistent with the history. I mean, we've had to learn this lesson over and over again. There were many people with sincere religious beliefs that God has ordained white supremacy, and people objected to the civil rights laws on those grounds, and those objections were rejected, and rightly so. And we've seen it with respect to sex discrimination, too. People certainly have held those beliefs and are free to hold those beliefs, but not to pay their women workers less. It really is the same principle, and if we keep the consistent principle in our non-discrimination laws, I think we will end up in a good place, as we have tried to do in other movements as well.
Let's give all of you an opportunity to answer questions from the audience. We have a mic here, and just flag down, Priya, and grab the mic and ask a very succinct question. If you want to comment instead of question, that's fine too, but make it to the point. Come on. Okay. Did I see some movement here? Anybody? Up.
I agree with you that this is very challenging because you have interests from very valid interests from different perspectives, right? I'm kind of wondering, we just had another state pass an anti-Sharia law. And my challenge on some of these religious freedom issues is it seems like, and I say this as a Christian, that Christianity is somehow held up higher than the other religions. And when the religions conflict over discrimination, that's where the challenge is. So I'm wondering, those of you who are on the side of really trying to protect religious freedom, where are you on those kinds of resolutions?
I think that's you, Joe.
Sure. No, we would broadly support those. When people talk about Sharia law, it's misleading in a way. What most people have in mind is something like honor killings or, maybe polygamous marriages. The answer is very simple. Those protections obtain, but if there are practices that for which the government, can show it has a compelling government interest, or under Smith, the general interest. Clearly, the government has a compelling interest in preventing murder, and there's no less restrictive way to prevent murder than to say don't kill. So I think it's not so much the religion, it's more the idea of what is the actual practice. If I was starting a church tomorrow, I might say our central tenet is we don't pay taxes, we don't believe in taxes. It'd probably be a very popular church with many adherents right away, but the government would quickly say we have a compelling government interest in your paying taxes. So I think the analysis inevitably falls on the practice. And there are many places that, religious beliefs have coextensive or overlapping types of beliefs. So I don't think it's as difficult a question as you pose, because Sharia law is not one all-size package, you accept everything or nothing. Yes, we make accommodations for people to have prayer cloths and a place to pray, and you make those sorts of religious accommodations, or to wear the head covering. But again, it's I think, an individual practice analysis.
Okay, next question, and while we're walking the mic to the next questioner, Professor, you had...
I was just going to say, I thought her question was, what about these laws that single out Sharia law? Not about whether Sharia practice...
Oh, they're blatantly unconstitutional.
Yeah, I would agree.
Yeah, we can all agree on that one.
Question from the audience, go for it.
Hi, the gentleman from the second from my right was talking about how religion and state has to be or religion and tolerance has to be a two-way street. I'm just wondering, what has religious entity at all given up or succeeded for there to be a two-way street?
Well, here's examples. I would never compel an African-American photographer to film a KKK rally. Well, somebody might say the KKK is not a protected class. Or I take the Westboro Baptist Church. I think we can all stipulate an odious speech. That's the group that goes to the veterans' funerals and protests and has really terrible signs about what God hates and all that. Would you tell a gay photographer that he or she must film that rally? Well, their religious beliefs are a protected class. Religion's a protected class. Would you compel that person to do it? Absolutely not. On the side of the photographer. So when I say it's a two-way street, I think both sides have to start that every human deserves an inherent dignity. We need to have a more genuine dialogue, not a dialogue where I'll listen until you agree with me, but a genuine dialogue we understand what is it that motivates you, what are your fears, what are the common human issues that you face that I need to be more understanding about. And I think what has happened with what I'm seeing now is if you have a traditional religiously informed answer, it has suddenly become dramatically the wrong answer. You must resign as CEO of Mozilla. If you gave money to Prop 8, there seems to be a sort of a hounding where now we're going to punish you for that or deny you. I could tell you cases where professors have been denied, a professional license because they have the wrong view of marriage or something like that. So when I say it's a two-way street, I think if we're going to get along together, there has to be a genuine understanding that there may have been abuses the other way where GLBT people suffered. We want to be sensitive to those things. I don't think the answer is to go so far the other way that a traditionally informed religious belief is now the wrong answer or we're going to punish you for it. That's what I meant by it.
Last question. You've got the mic there.
We have a question over here.
Yeah, go for it.
My question is, it's a very interesting discussion, and given the audience here, I wonder if people could comment on whether there is an Asian American perspective on this issue, or should there be one, and what it would be.
Jansen, Dipti, one of you, both?
Thank you, I've been dying to jump in here. I will answer that in a second. I just want to say that I think what Jenny was saying about the history of religiously based discrimination is really important. And I also start with the assumption that religious belief is really central and core to people's understandings, and the person, the florist, who doesn't want to provide the services to the gay and lesbian couple is acting out of her religious belief. And so there is a
only
two.
For the wedding.
Only for the wedding.
She served them for many years.
Okay,
Yes,
but APAs.
But it's a two-way street, and the state is an actor, is a traffic cop in that street, and we have to be really sensitive to that, right? So it is not, I think, an accident right now that all of these issues are coming up in the context of women and LGBT people. And it's partly because we haven't gotten to a point yet in our society where where the government fully puts a stamp of approval on the full equal dignity and humanity of women and LGBT people. And I think as Asian Americans who have suffered from that type of history of discrimination as well too, we have an obligation to make sure that we include all of these groups into the same cultural norms of humanity and dignity. I note that the conference is talking about convergence. I think this is a great example of that. How do we converge our communities together so that our state, as a government actor, respects the full humanity of all individuals?
Dipti, you want to take a quick try on that question?
I mean, I think all of the issues that we're talking about, when we're talking about gender, for example, as I mentioned, a lot of the reason that these laws are passed is because the government has recognized that certain services aren't available to certain individuals or communities, whether it's because they have disproportionately lower incomes, whether it's because perhaps there's not access to counseling about reproductive health, or there's not access to contraception. And that's why we pass these laws. We pass them across the nation to ensure that this isn't a fragmented system state by state. We make laws like the ACA for no cost sharing because we recognize that women have lower incomes. They have higher out-of-pocket costs for healthcare. So the reason that these laws are passed is in recognition of the fact that some of our communities, unfortunately, still today are disproportionately impacted by prejudice, by lower incomes, and by a lot of other things that are happening. And so when we're talking about this balancing act, we can't lose sight of that. And so when we talk about Hobby Lobby and these other cases, often you can have an entire discussion with never even talking about the fact that these are women employed by these companies that now may not get access to a service that they are entitled to. And it's not because they don't want them or their families don't want them, it's because their employer doesn't want them to have it. And so when we're talking about these issues, we have to decide how are we going to balance that right. The employer's belief is the employer's belief. But when does that trump somebody else's belief about a healthcare service or any other service that they might want to participate in?
So here's how we're going to wrap up.
Kevin,
we really have to end
No,
up
but
here.
this is very quick. I just want to say, in response to the question about the APA perspective, I wanted to say in honor of my Chinese American parents-in-law that there are many traditions and that it's a respect for the diversity of traditions to say everybody should do business with each other and not turn people away based on religious traditions or cultural traditions. That's a way of respecting the diversity of traditions, including the diversity of the traditions that we honor in this country that may have started across the water, but that we think are really important here. We should respect that and do business with each other.
Okay, I want all of you to think back of the second scenario. I'll repeat it for you. The owners of a family-owned winery believe that women should not serve alcohol. Because of their religious belief, they do not hire women in the tasting room of their winery. When sued by the state of NAPABA's Fair Employment Commission, they assert that they should be exempt from the state's employment discrimination laws based on their religious belief. If that's all you knew, and put aside what the law actually is, I'm going to ask you in 15 seconds, how many people think the winery should be exempt, or how many people think the state should win and enforce the employment discrimination laws? Okay, ready? So this will be just quick raise of hands. How many people think the winery should be exempt? Raise your hands. Don't be shy. I polled some of you guys last night, and there were a lot more than that. Okay, how many people think that the state should be able to enforce the laws against the winery? Raise your hands. Okay, and how many people did not raise your hands on either option? Raise your hands. Well, I think it's a credit to all of our panelists that all of you now have enough in your toolkit to actually think about the issues and at least have a tentative view. Thank you very much to everybody.